You're hearing maybe Mueller is winding down his investigation and preparing his report for the Deputy Attorney General. Now, he should be preparing his report for the Acting Attorney General, Matthew Whitaker. He should be following the Department of Justice rules. But whatever. And then you have these lawyers. Understand we have so many lawyers in this country, and we have a whole lot of stupid lawyers in this country. We even have lawyers who are stupid, who become professors, associate professors, assistant professors, adjunct professors. Some of them work on Wall Street. One of them's married to Ms. Conway in the White House, Kellyanne Conway, calls himself George, Porky George. And he's out there saying that Trump waving around this pardon to Roger Stone now, it's witness tampering, and he cites 2 federal statutes. Witness tampering, and he cites 2 federal statutes. Now, what you're not going to hear, except from me for 4,000 times, is that the President of the United States cannot be indicted by Mr. Mueller. The President of the United States cannot be indicted by Mr. Mueller. Mr. Mueller has reached the same conclusion, apparently. And I think this is why Mr. Mueller is not going to take this subpoena issue all the way to the United States Supreme Court. Now, in truth, who's been right about this from day one? I've been right about this from day one. All of it. All of it. And that's based on experience. As somebody who was chief of staff to an attorney general for several years, as somebody who represented a client, the former attorney general in the Iran-Contra matter, as somebody who has studied the former independent counsel statute, as somebody who studied the memoranda, 1973 and 2000, put out by the Office of Legal Counsel on whether or not you can indict a sitting president in the position, the official position of the United States Department of Justice. And then you dig into the regulations under which Mr. Mueller was appointed, and you come across 28 CFR section 600.7a. Special counsel must comply with the rules, regulations, procedures, practices, and policies of the Department of Justice. I've read this on the air here. I've read this on the air on Fox and on LEVIN TV. So the President of the United States will not be indicted. The President of the United States is not in any kind of quote-unquote legal jeopardy. And he never was. Now, this is apart from the fact that all the leaks and all the tea leaf readers and all the fool Democrats and all the fool media types are all over TV just can't put the dots together to show that Donald Trump, in some way or any way, was working with the Russians to affect the outcome of this election. And you know damn well if he had, we'd know about it by now. And you know damn well if we had, the Obama administration would have leaked it because they were in charge at the time. So let me address yet again the latest idiocy coming out of George Conway's mouth, as well as the mouth of others. I have in front of me a copy of the October 16, 2000 memorandum for the Attorney General from the Office of Legal Counsel, the official office that interprets the Constitution for the administration, including the Attorney General, which I first mentioned almost 2 years ago on Fox. And they've concluded that unlike judges, unlike cabinet secretaries, unlike other public officials, the President of the United States must not be indicted by the Department of Justice. And I just read to you the regulation that says that Mr. Mueller must comply with the Department of Justice rules. Now, before I get into this again, of course, it doesn't mean that Mr. Mueller can't write up a report loaded with attacks, loaded with his poison and all the rest of it. But this is why most United States attorneys, all United States attorneys, are not to write reports of this sort. This is why this special counsel report is so damaging to the rule of law. And it's a very big weakness in the special counsel regulation. He should not be writing reports. He either speaks in the courtroom or he doesn't speak at all. Because otherwise, when you open an investigation of a sitting president, you have two purposes. Or maybe one of two. The first is to try and create an impeachment document. Well, ladies and gentlemen, it is not the role of the Department of Justice or a special counsel accountable to no one to be involved in a political/constitutional process, the impeachment process. If Congress wants to investigate a president respecting impeachment, that's up to Congress. But it's not up to the executive branch, let alone a special counsel. Which is also what makes this special counsel quite different from other federal prosecutors and makes his appointment, in my view, unconstitutional in violation of the Appointments Clause. Number two, you can conduct an investigation because you want to determine if other people have violated laws who are in the president's orbit, who can be prosecuted, and perhaps get information related to activities, not official activities, but previous activities, private activities, that would serve as a basis for an indictment after a president serves his term or terms. That's not the case here. The appointment of Mueller was based on collusion with Russia during the course of the election. So that's not the case here. Now, we'll go through this again. Take our time. There's no hot news out there where we need to jump in and speed through it, and I'm not going to. But I want to make sure you're informed about this because this may, in fact, be coming toward an end. And there's one other thing I want to mention before I get into the memo, or memos, and it's this. Can you imagine if President Trump had sat on his hands throughout the entirety of this investigation and didn't tweet anything or didn't say anything while the Mueller people were leaking, while members of Congress were going on TV accusing him and his family and his associates of all kinds of treason, subversion, criminal activity? Do you think this president would have anywhere near the popularity that he has today, even though he's attacked, his popularity is not high? It would be completely in the tubes. So he fights back, and that's what a lot of people like about this, that he fights back. Whatever happens to Cohen or Manafort or General Flynn, the latter of whom I'm very fond of, is of no relevance in terms of the prosecutor's investigation, in terms of any criminality that might be found, or alleged, I should say, respecting the campaign and the president. I don't know about you, but I need a neck brace about now. Surging left, surging right, this is the big one, Corsi, this is the big one, Stone, Flynn's the big one, Gates, now we got him, Papadopoulos is all over it. The media are disgusting. You know, in the Federalist Papers, the great men who wrote the Federalist Papers warned against faction, in particular Madison. They warned against faction. And Jefferson, who was not involved in the Federalist Papers, but he warned against faction. They were worried about it. And yet we have faction in the media. The media represent a small faction of the body politic, and that's not the purpose of a free press. To be the mouthpiece for the radical left within the Democrat Party, which they actually lead. So when we return, we'll take our time. I don't want you to fret with all the people on TV and radio going on and on about witness tampering and all the rest. There hasn't been any witness tampering. The President of the United States is not going to be indicted. The battle will be in Congress, of course. You see, Mr. Mueller was never going to be able to indict a sitting president. And this has been my frustration for 2 years, almost 2 years, where I've written about it, where I've gone on TV to talk about it, where I've gone online to talk about it, where I've discussed it with you on radio, because you have these people who are, I don't know where they get them from, who are commenting all over the place, who do not comprehend events. Former federal prosecutors who are former federal prosecutors. They're not constitutionalists. Or they haven't done the homework necessary to know what they're talking about. Or law professors who haven't done the homework to know what they're talking about. I can remember 18 months ago, 14, 12, whatever it was ago, there was talk that Mueller would subpoena the President of the United States, remember? And the President would have to comply with the subpoena, or he could be forced in front of the grand jury without recourse. I said, whoa, that's absolutely false. And some of these people who've made arguments like that are still on TV, still commenting. They're not held to account. But we'll be right back. Now, ladies and gentlemen, the President of the United States will not be indicted. The President of the United States has not witness tampered. The President of the United States has not obstructed justice. The President of the United States has not conspired or colluded. He's done nothing. And the fact that this word impeachment has been hanging over his head and his administration like a dark cloud even before he was inaugurated is truly unconscionable. Absolutely unconscionable. It's been driven by the media. It's been driven by the Democrat Party. And this has been the reality that we've had to live in now for almost 2 years. It's a propaganda mill. It's repeated over and over again. So it gets into your psyche. So rather than talking about other things related to the president's policies or the administration or what have you, this seems to lead off the news, doesn't it? Now, if Mr. Mueller is required to comply with Department of Justice regulations, which he is, and if Mr. Mueller cannot indict a sitting president, which he can't, then what's all the hubbub about? He's got Michael Cohen, who's a crook. It's like a mob lawyer. Michael Cohen was in it for himself. He violated every ethical code I can think of. He ripped off the public with respect to his taxi medallions. He ripped off the public with respect to not paying his taxes. He ripped off banks, apparently lying about his mortgages. He lied to Congress, and yet he's held up by his Democrat lawyers like Lanny Davis, among others, and he's held up by the media as the man who can bring down Trump. Really? How so? Because of a meeting, you see, at Trump Tower. The president said he wasn't aware of the meeting. Don Jr. says the president wasn't aware of the meeting. There was no transaction, nothing done during the course of the meeting. So who gives a damn about the meeting? They got General Flynn, don't you know? The FBI took a pass on General Flynn early on. He couldn't remember something well, and it was of no real consequence. Mr. Comey said that the FBI had determined that it wasn't an intentional false statement. And then comes Mr. Stroke, an adulterer, a Trump hater, a man who abused his office, who violated his oath as a senior FBI official, and used his power in an enormously corrupt way. he determined that Mr. Flynn should be charged with a false statement. And, of course, Mr. Mueller and his merry band of left-wing kooks, they agreed. They agreed. Then you have Mr. Manafort. It's an amazing thing. You have a United States attorney in the Eastern District of Virginia. We have a United States attorney in Washington, D.C. We have 93 United States attorneys all over the country. And not one of them brought charges against Mr. Manafort. And yet we're told that the charges in Virginia and the charges that were brought in Washington, D.C. were so overwhelming over the course of many years. Well, then why didn't Mr. Mueller, when he was director of the FBI, recommend charges be brought against Mr. Manafort then? Because Mr. Manafort hadn't been campaign chairman or campaign manager of the Trump campaign for 4 months. He had to pay a price for that. And, of course, they put the squeeze on Mr. Manafort's former son-in-law. They put the squeeze on his former partner, Gates, among others. People go broke. People have breakdowns. People don't want to go to prison. And they'll do anything, particularly if they're weak, to stay away from all of it. Mr. Mueller knows that, as do his 17 prosecutors. What else do they have? Mr. Papadopoulos, you see, gave a false statement, they claim. And so crucial was the prosecution of Mr. Papadopoulos for making a false statement, which he now says he didn't make a false statement. He was tricked. He will have served 2 weeks in jail. 2 weeks. The entire interference in our election by the Russians occurred on Barack Obama's watch, on Clapper's watch, on Brennan's watch, on Comey's watch, on Loretta Lynch's watch, on John Kerry's watch, on Joe Biden's watch, on Barack Obama's watch. Not one of them are held responsible for failing to do anything effective to stop it or to even inform the American people about what was taking place, because they were concerned, you see, that should Hillary Clinton be elected, which they were sure she would be, that it would taint her presidency. So they sat on it. There were also FBI spies in the Trump campaign, at least 2. 2 spies from the Obama administration's FBI in the Trump campaign. A FISA court warrant extended 3 different times based on the opposition research paid by the DNC in the Hillary Clinton campaign, the opposition research which was a lie. No federal judge has been held to account. No federal judge has held Mr. Comey or the FBI to account. That is, the federal judges on the FISA court. There was a deputy attorney general by the name of Sally Yates. And she was an Obama holdover. She became the acting attorney general because the Senate under Schumer was slow-walking the president's nominees for these various cabinet positions. On her staff was a fellow by the name of Bruce Orr, Associate Deputy Attorney General. I was once an Associate Deputy Attorney General. It's a big job. And he used his position in part to feed information to the man who wrote the dossier, Christopher Steele, who used his position to feed information back to Bruce Orr on the Deputy Attorney General staff. And his wife worked for Fusion GPS. Right there at the top levels of the Department of Justice. We had connections to the dossier, the people who wrote it and the people who funded it. He never recused himself. No, he was an activist. Early on, there was what we call unmasking. Individuals caught in various surveillance and espionage activities where there's eavesdropping taking place, American citizens under the Patriot Act, they are to be protected. They are only to be unmasked if there may well be a national security issue. And even then, under the most confidential of circumstances. Susan Rice was unmasking individuals left and right. The ambassador to the United Nations, Power, she was unmasking individuals left and right. Among those unmasked was General Flynn. General Flynn obviously was to be the incoming national security advisor to the President of the United States. Of course he'd be talking to the Russians and everybody else. Why wouldn't he be? His name was leaked. It's a felony to unmask and leak. Nobody's ever been charged for that. To the best of my knowledge, nobody's even been investigated for that. Now we're told Mr. Mueller's wrapping up his investigation. Other than Congress, there's been no criminal investigation. The Hillary Clinton campaign, of the DNC, of Perkins Coie, the law firm that washed the money through this lawyer Mark Elias that went to Fusion GPS. There's been no criminal investigation of Fusion GPS. There's been no criminal investigation of Christopher Steele, a foreign agent, formerly. There's been no criminal investigation of the FISA court. None. And as I say, to the best of my knowledge, there's been no effective criminal investigation of the unmasking and the leaking of General Flynn's name. And yet we are told that it is the president who somehow has committed impeachable offenses. It's the president who's witness tampering. It's the president who has obstructed justice. He's done none of these things. Donald Trump is the victim. The members of the Trump family are the victims. Memorandum for the Attorney General dated October 16, 2000. In 1973, the Department concluded of Justice that the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions. We've been asked to summarize and review the analysis provided in support of that conclusion and to consider whether any subsequent developments in the law lead us today to reconsider or modify or disavow that determination. We believe that the conclusion reached by the Department of 1973 still represents the best interpretation of the Constitution. 3 types of burdens. Now, what's interesting about what I'm telling you is it's no secret. Moreover, I doubt a single anchor person on cable, on MSNBC or CNN have read it, or even care. Now, what are these considerations? A, the actual imposition of a criminal sentence of incarceration. In other words, if you're going to indict a sitting president, the purpose isn't just to indict. It's to convict, to sentence, to imprison, which would make it physically impossible for the president to carry out his duties. B, the public stigma and opprobrium occasioned by the initiation of criminal proceedings, which could compromise the president's ability to fulfill his constitutionally contemplated leadership role with respect to foreign and domestic affairs. And C, the mental and physical burdens of assisting in the preparation of his own defense for the various stages of the criminal proceedings, which might severely hamper the president's performance of his official duties. In assessing the significance of these burdens, two features of our constitutional system must be kept in mind. First, the Constitution specifies a mechanism for accusing a sitting president of wrongdoing and removing him from office. Article 2, Section 4 provides for impeachment. Impeachment by the House, removal from office upon conviction in the Senate of sitting presidents found guilty of, quote, treason, bribery, or high crimes and misdemeanors, unquote. While the impeachment process might also, of course, hinder the president's performance of his duties, the process can be initiated and maintained only by politically accountable legislative officials. Supplementing this constitutionally prescribed process by permitting the indictment and criminal prosecution of a sitting president would place into the hands of a single prosecutor and grand jury the practical power to interfere with the ability of a popularly elected president to carry out his constitutional functions. That one sentence really underscores everything. A single prosecutor, elected by nobody, accountable to nobody, can determine the fate of a president. That's why when I watch what's going on in Israel, how they're trying to destroy Netanyahu, it's a damn shame. These are historic figures. Second, the president occupies a unique position in the constitutional scheme. As the Supreme Court stated in the Fitzgerald case, Article 2, Section 1 of the Constitution provides that the executive power shall be vested in a president of the United States. This grant of authority establishes the president as the chief constitutional officer of the executive branch, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. In addition to the grant of executive power, other provisions of Article 2 make clear the broad scope and important nature of the powers entrusted to the president. Very important. The practical demands on the individual who occupies the office of the president, particularly in the modern era, are enormous. President Washington wrote that the duties of my office at all times require an unremitting attention. In the 2 centuries since the Washington administration, the demands of government and thus of president's duties have grown exponentially. In the words of Justice Jackson, in drama, magnitude, and finality, the president's decisions so far overshadow any others that almost alone he fills the public eye and ear. The burdens imposed on a sitting president by the initiation of criminal proceedings, whether for official or unofficial wrongdoing, therefore must be assessed in light of the court's long recognition of the unique position in the constitutional scheme that this office occupies. Given the unique powers, by the way, I'm not reading the whole memo, I'm skipping around to the parts I thought that you might be interested in. Given the unique powers granted to and obligations imposed upon the president, we think it clear that a sitting president may not constitutionally be imprisoned. The physical confinement of the chief executive following a valid conviction would indisputably preclude the executive branch from performing its constitutionally assigned functions. Now, you heard a lot of talk about the 25th Amendment. And, of course, I engaged in that debate. But you heard talk about it from people as foolish as Joe Scarborough and many others. They wrote, to be sure, the 25th Amendment provides that either the president himself or the vice president, along with a majority of the executive branch's principal officers, or some other congressionally determined body, can declare that the president is, quote, unable to discharge the powers and duties of his office. The result that the vice president assumes the status and powers of acting president. But it is doubtful in the extreme that this amendment was intended to eliminate or otherwise affect any constitutional immunities the president enjoyed prior to its enactment. None of the contingencies discussed by the framers of the 25th Amendment even alluded to the possibility of a criminal prosecution of a sitting president. Of course, Might be argued that the 25th Amendment provides a mechanism to ensuring that if a sitting president were convicted and imprisoned, there could be a transfer of powers to an acting president rather than permanent disabling of the executive branch. But the possibility of vice presidential succession hardly constitutes an argument in favor of allowing other branches to take actions that would disable a sitting president. Got that? The purpose of the 25th Amendment isn't to substitute for the impeachment clause or to add on to the possible criminal indictment or prosecution of a president. There's nothing in its history that suggests that. And I might add, under the 25th Amendment, the vote required is 2/3. So it's stupid to begin with. Impeachment requires a majority of the House. Removal under the 25th Amendment requires 2/3 of the House. So when you had these fools who hate Trump, who are desperate to try and remove him through some kind of a coup, talk about the 25th Amendment, they had no idea what they're talking about on several levels. Now, putting aside the possibility of criminal confinement during his term in office, the severity of the burden imposed upon the president by the stigma arising both from the initiation of a criminal prosecution and also from the need to respond to such charges through the judicial process would seriously interfere with his ability to carry out his constitutionally assigned functions. They're talking about things like today, China, Russia, all kinds of issues that have to be addressed while these charges are going on. Once criminal charges are filed, right, the burdens of responding to those charges are different in kind and far greater in degree than those of responding to civil litigation. You'll hear people talk about, what about Clinton versus the United States? The Supreme Court said in the Paula Jones case he has to, he has to participate in that process. And as they explain here, it's different in a civil case. The constitutional provisions governing criminal prosecutions make clear the framers' belief that an individual's mental and physical involvement and assistance in the preparation of his own criminal defense, both before and during any criminal trial, would be intense, no less so for the president than any other defendant. The Constitution contemplates the defendant's attendance at trial and indeed secures his right to be present by ensuring his right to confront witnesses who appear at trial. The Constitution also guarantees the defendant a right to counsel, which is itself premised on the defendant's ability to communicate with such counsel and assist in the preparation of his own defense. These burdens inhere not merely in the actual trial itself, but also in the substantial preparation of that a criminal trial demands. What they're saying is, a civil trial requires a lot. It's not the same as a criminal charge, where your liberty's on the line. Where your liberty's on the line. You look at the relevant parts of the Bill of Rights. They're focused really on criminal trials. Civil litigation, private parties typically, not always, but private parties typically duking it out. I mean, there are civil cases involving the government, but in a criminal case, it's always the government. In some, unlike private actions for damages, like the Clinton versus Jones case, criminal litigation uniquely requires the president's personal time and energy and will inevitably entail a considerable, if not overwhelming, degree of mental preoccupation. Indictment also exposes the president to an official pronouncement that there's probable cause to believe he committed a criminal act, impairing his credibility and carrying out his constitutional responsibilities to take care that the laws be faithfully executed. So far, to sum up, what are they saying? They're saying the president is a very, very unique position. Unlike multiple members of Congress, thousands of members of the bureaucracy, 1,000 federal judges. He is the executive branch. He is the commander-in-chief. He's the one person elected by the entirety of the country. Nobody else is. And unlike civil litigation and criminal litigation, it obviously is an individual prosecutor having the power to upset the constitutional scheme, an individual having the power to change the relationship of one branch against the other, an individual having the power to interfere with foreign relations, domestic policy, that individual being a prosecutor, and no individual should have that kind of power, as they write. More when I return. I hope you find this interesting. Either way, it's important, and I think this is the kind of forum in which a more substantive discussion of it can take place. Now let's continue a little further. And this puts everything in context, I think, doesn't it? People talk about witness tampering and obstruction. What witness tampering and obstruction? But beyond that, if you understand what they're trying to do to your Constitution, if you understand what they're trying to do to your office of the presidency, and this transcends this president, it's every president, then you understand how diabolical they are. Now, this is the position not of Mark Levin. This is the position of the United States Department of Justice. This has been the position of the United States Department of Justice since 1973, underscored in 2000. So, we'll continue with this and complete it when I return. Let's continue. Maybe I'm just kind of weird. I like this stuff. Am I weird? Is that where you are, Mr. Producer? Do you find this interesting? You can tell me the truth. No, thank you. Well, if I'm weird, imagine what you are. All right, that's a whole other story. But I'll finish up. Going back to this 2000 memo. The constitutionally prescribed process of impeachment and removal lies in the hands of duly elected political, accountable officials. By contrast, the most important decisions in the process of criminal prosecution would lie in the hands of unaccountable grand jurors, deliberating in secret, perhaps influenced by regional or other concerns not shared by the general public, guided by a prosecutor who is only indirectly accountable to the public. And this should frustrate the hell out of you that they just keep cheering and cheering for the unaccountable prosecutor to try and take out the popularly elected, via the Electoral College, President of the United States. Thus, the constitutional concern is not merely that any particular indictment in criminal prosecution of a sitting president would unduly impinge upon his ability to perform his public duties. A more general concern is that permitting such criminal process against a sitting president would affect the underlying dynamics of our governmental system in profound and necessarily unpredictable ways. By shifting an awesome power to unelected persons, lacking an explicit constitutional role vis-a-vis the president. Given the potentially momentous political consequences for the nation at stake, there is a fundamental structural incompatibility between the ordinary application of the criminal process and the office of the president. Now, I don't believe this is debatable, do you? I truly don't. The same people who would destroy our capitalist economic system, the same people who would destroy our borders and our sovereignty, the same people who would eviscerate our Constitution, are the same people insisting that this president be taken out. And they will not wait till the next election cycle. Now, let me put a footnote onto that. I don't know that they have the guts to trigger this or not. Maybe they'll have hearings, maybe they'll press the point, maybe they'll get to that stage. I don't know. But it'll actually be actually be politically smarter if they didn't. Politically smarter if they didn't. You see what's going on in France? I kind of hinted about this the other day. You see what's going on in France, in Paris, with the climate change radical kooks? That is Macron. want to drive up the price of a gallon of gasoline to $7 a gallon. It's an amazing thing. People say, yes, let's fight climate change. Yes, I want cleaner air. Yes, I want this. Yes, I want that. All right, it's going to cost you $7 a gallon. Let's burn Paris down. There is a huge disconnect between the left's policies and their theories and the reality that kicks in. And it's like Obamacare. They tell, well, Obamacare is popular now. No, it's not. If you explain to people about their deductions, explain to people what is and isn't covered, explain to people the bureaucracy and how difficult it is to get a specialist now or even find a generalist. And these things have real consequences for human beings, real live human beings. What you saw originally in Paris was a tax revolt. Now, various left-wingers have tried to step in and take charge of the thing, which is kind of odd since Macron is a left-winger and he's doing left-wing things, which is what the revolt is all about. It's a tax revolt. But the people said no. Now, they're joined in by the students because, over there, the students, look at that, a fire. Can we participate? And, of course, they are. But I'm talking about the original triggering of this. And when you mess with the public's election process, when 65 million people voted for the current president of the United States, and you use the most specious bases to try and drag down the candidate who won or try and remove that candidate from office, there are consequences for that. I'm not encouraging it. I'm just telling you there are consequences for that. You create an anger. You create even a fury among people who believe, and rightly so, that this is in fact a coup. And the fact that the media support it and push it, of course, doesn't make it any better. It makes it worse. The media are supposed to, under the freedom of press, are supposed to sort of be a balance. They're supposed to be where free speech meets. But they're not now. They're just not. They represent, as I said at the top of the first hour, a faction of society. That's how most of these news outlets have decided to run their businesses. And they will tell you that they exist to protect freedom of the press. You know what? That argument's not good enough anymore because it's not true. That argument is not good enough anymore because it's not descriptive of what's actually taking place. The media, that is, freedom of the press, like all the rest of the Constitution, is a function of what it is that's best for the citizenry, for the people. Now, I don't mean to say that as a platitude, but that should be what drives them. But it's not. What drives them is their progressive ideology. And that's the problem. All right. Let's see here. Tim, Corona, California, the great KPAY. Go right ahead.
Hey, Mr. Levin, I appreciate your show. Great show, first-time caller.
Thank you.
My question is, what are the chances of one of the persons who Mr. Mueller got to plead guilty, whether it's Manafort, Papadopoulos, or one of the others, doing an appeal all the way to the Supreme Court to have Mr. Mueller's appointment deemed improper, unconstitutional? I call him the illegitimate son of the Democratic Party. And then throw out Mueller and his band of cutthroats, because subject matter jurisdiction, I believe, is never waived, even if they've pled guilty to a crime.
No, that's a good point. I agree with you. And I believe one of those cases is bouncing around at the district court level or the circuit court level, up and down between those two courts in Washington, D.C. right now. and I believe it is. I don't know. It's being litigated, in secret. But people are trying to read the tea leaves. I know there's another case with a Roger Stone colleague, I believe, who is flat out challenging the appointment as unconstitutional under the Appointments Clause. And I think a very strong argument could be made. This is not the 1988 case. This is quite different. You have a prosecutor here that Congress wants to protect. Do you know of any other prosecutor Congress wants to protect, Tim?
No.
You have one second. You have United States attorneys who have to be appointed by the president and confirmed by the Senate. I would say Mr. Mueller is at least as powerful as a United States attorney, wouldn't you?
Yes, that's what scares me, that so many people want to protect him, and I don't believe he is qualified to be protected under the Constitution because his appointment was improper, like you have said. His
appointment is not only improper, but Congress has absolutely no constitutional authority to protect a member of the executive branch from being fired from the head of the executive branch. It's a clear separation of powers issue. And yet you have Republicans who claim to be conservatives, who are insisting that they needed to pass legislation. And as a practical matter, of course, the president would veto it. But let's say it was veto-proof, that the numbers were so big. The point still is that Congress has no authority to do that. And I don't believe Mr. Rosenstein had the authority to appoint Mr. Mueller with the wide breadth of investigative authority that he had without on the underlying criminal statute. All right, Tim, thank you for your call, my friend. You folks are getting constitutional law lessons more than most constitutional law students get. No brag, just fact. Tim, Tucson, Arizona, the great KNST, go.
Mr. Levin, my question is this. Why is Rosenstein handling Mueller's report? Why isn't Whitaker, who's acting AG, taking it under his wing?
This is a very, very good question. And to answer your question, Whitaker should be handling it. And Rosenstein should have no role. He's the Deputy Attorney General now, not the Acting Attorney General for these purposes. And he's conflicted up the wazoo. You're right.